Hello, everyone, and thank you all so much for joining us on our weekly webinar. Today, I'm joined by our awesome managing attorney, Ruby Powers, and we are here to discuss the conditional residency. What is the I-751? Just some quick background information on our attorney. She has been licensed since 2008 and founded her firm back in 2009. She is also a board certified immigration and nationality attorney. Attorney Powers, do you want to go ahead and take it away?
Yeah, thank you so much. So this is a topic that happens for a lot of people that is a concern because if you've been married less than 2 years at the time of the adjudication of your green card, you will only be given a 2-year green card, and this could happen for you as a spouse or even for children that are the dependents of someone who got their 2-year green card through marriage. So there's a lot of little quirks about it. And so we're going to go over those details here. Again, this doesn't take the place of legal advice, as you should always have a consult to review your own individual case. But we're going to go over some things to consider, the reasons why you can apply for an I-751, and also things that happen if the case gets denied. So this all stemmed from a law that came out, the act that came in 1986. There was Immigration Fraud Amendments Act. And so for depending on your age, a long time ago, there was this movie called The Green Card with Gerard Depardieu. And so there... that was a funny movie. I need to watch that again. But basically, he gets into his marriage to basically get his green card, and they are taking fake photos and all this other stuff. So things you're not supposed to do. But I won't spoil the movie for you. But and then if you're more recent movie, it's called The Proposal with Sandra Bullock and Ryan Reynolds. And I mean, there's a lot of things wrong in that one because, like, the USCIS officer, like, supposedly following them all over. Like, that doesn't happen anyway. But anyway, so I digress. But basically, the problem is a lot of times people know whatever they know about conditional residency or marriage and green cards is from movies, and maybe more recently they're seeing stuff on YouTube or TikTok and stuff. So we wanted to make sure that we get the story straight. So conditional residency is temporary. You have to still remove that condition by filing the I-751, which is what this webinar is about. And then we're going to get some practice pointers about successful ways to do it. So let's go ahead and go on to the next. So the requirements it's for joint petition is that a joint petition means you're filing it together. And you're wanting to show that the relationship is still intact, you're living together, you're commingling funds if that's what you were doing before, and that you are they both sign the joint sponsor. A joint petition means you both sign the I-751. Now you want to make sure that you file it within 3 months before the expiration date of the expiration date of the green card. And you also want to make sure that you want to do that for multiple reasons. One of them is to make sure that you get the receipt given to you. So we can go ahead and move to the next slide. But I love these photos, though, because the one on the bottom is from the green card, where they're like, you see where they're in New York and they're pretending like they're on a ski trip, taking the Polaroid camera. Anyway, so the timing of the filing is it's within 90 days before the 2-year anniversary of the green card. And this doesn't apply to waivers. So that means you don't have to wait for those 90 days if you're filing for a waiver, which means a waiver means you're not filing a joint I-751. You don't need to be in the United States to file the I-751, which is good to know. And there's no limit to the number of I-751s a person can file. The thing is, you don't really want to make sure you don't file that many of them, right? Because it gets expensive and timely and takes time. But you want to make sure that you that whatever you do, you do it well. And so a lot of times people get their green card, they're so excited, and then they don't really read it. So what I would suggest is when you get that green card and as the conditional is look at the date that it says it expires, and then put a tickler somewhere in your calendar, maybe like 4 months before it expires, so you can start thinking about it. And like for what we do for our clients is we put a tickler to reach out to them before that expiration, so that ideally we could file about that. Like we reach out to them about 4 months before it expires, so that we could be filing like right at the 3-month mark. Because when you submit it, you're going to get a receipt that gives you an extension, and you're going to need that for a driver's license, travel, work, and all that good stuff. So let's move on to the next slide. Now, if a child received the residency through conditional resident parent, it's the same deal. They would have to file within the 90 days to remove it. But they can be included on the parent's jointly filed I-751. But each child would be, depending on the age, regardless of the age, would have to file the biometrics fee. So let's say there's a primary parent that got the conditional resident, and then they have 2 kids. So they would have the primary fee, regular fee, and the biometrics for the parent and the 2 kids. You wouldn't have to do 3 I-751s. There is this one thing to consider, though. If the parent and the kids got their, I don't remember exactly the date, but if they got their green cards really far apart from each other for some particular reason, then in some cases you do have to file 3 separate I-751s. But if it was within a smaller, it's right here, it's within 90 days of the parent, then you don't have to do that. So that's something to consider. It can get a little confusing, but we did have a case like that where the parent got it before the children, because we did the parent through adjustment of status and we did the children through consular processing. Because you're like, how did that happen? Well, that's how it happened. And so if the parent and the children all get it approved within 90 days, you can get it under one I-751. If not, you would have to do separate ones. So if there's no concurrent acquisition, if the parent is deceased, or if the parent is divorcing, or if the child is separated from the parent, then the child would have to file their own separate petition. Now, we've found, this might be getting a little too in detail, but we once filed an naturalization for somebody who, come to find out, his mom never filed for the I-751, so he was a child dependent on that, and he should have filed I-751, but USCIS had made a mistake and didn't give him a conditional green card. They gave him a 10-year green card. So while I'm on this slide, I just want to say sometimes USCIS makes mistakes, and they give you a 10-year when they should have given you a 2-year. And you really shouldn't celebrate that, because it's later going to be a problem later when you try to naturalize. So in that situation, it's best talk to an attorney. But basically, what I would do is, if you should have gotten the 2-year and you got the 10-year, I would file an I-751 and explain the situation to make sure that you've covered your basis by the time you apply for naturalization. So let's move on to the next slide. Now, if for any reason you file late, it's not the end of the world. Sometimes I've seen where it got my client in court, because a former client that filed didn't hire us to take care of the I-751, and when, let's see, how did that work? I think a late filing instigated them being put in court. That was a few years ago. But generally, you can just say, please accept this late filing because XYZ happened. So good causes can be hospitalization, long-term illness, recent birth of a child, active duty. It could be, I just didn't realize it. It's not a good excuse, but we've done that before, because people they get busy and they don't look at the card and the date. As long as you file it as soon as you realize and overcome these reasons that constitute the delay, and you have to put in that language, please excuse the late filing, something along those lines, you have to do that. They'll still give you the receipt, and that receipt will be good for more time, and that'll give you that peace of mind to get your stamp in your passport if needed for driver's license, work authorization, and all that good stuff. So you can still overcome it. We can move to the next slide, but basically I had a case, I think she had waited almost 7 years, but it was, that's an anomaly, but I think there was a lot of abuse and some matters that happened. It just really kept her from being able to stay focused. Most people do notice at some point, because their driver's license expires or their employer might say something at some point. Now, if you talk about waivers, waivers means that you're not getting the spouse to sign. And so for some reason, you're not still married or you're going through a divorce or something along those lines. So the waivers could be under multiple reasons. One could be because the marriage was terminated, but it was a good faith marriage, which means it was when you said I do, you thought it was going to last forever, but it just didn't work out. So you really thought it was going to be real. I mean, you thought everybody thought it was real, but it didn't work for whatever reason. So that's what we call the good faith marriage waiver. The other, but you need to have the divorce proof of that. Now, annulment's generally not something you would want because that can be considered that you weren't really married in the first place. So be careful about doing that, depending on the state law. But I generally advise against getting an annulment. The other thing, like we had said, is that when you're using a waiver, you don't have to wait for the 90 days beforehand. So as soon as you have the divorce, you could file the I-751 as soon as you have that divorce. You don't have to wait 90 days before the expiration of the card. Also, if there's battery or extreme cruelty, I usually liken this to like a Violence Against Women Act type of a petition. You can establish that. If you have the proof of that, again, you don't need a divorce decree to file. Sometimes there's delays because of the situation with the marriage. And second of all, if it gets approved under that provision, you can apply for citizenship under the 3-year rule eventually, like VAWA. The other thing, a waiver would be under extreme hardship. So these are all different ways that you could do this. So let's move on. So good faith marriage. We're going to go a little deeper dive real quick. So the good faith marriage is you thought it was going to last, it just didn't, and you have the divorce decree. You're going to want to show as much proof as possible of the relationship, and it is the burden of the applicant to demonstrate that it was real. I even had some cases where the American spouse actually filed a letter saying, it just didn't work out. But that was rare. But really you want to show a lot of the same proof you would if it was a joint. You would show the bank statements, taxes, ownership, insurance, health, life, everything-ish, everything. And so that's pretty much the good faith one. So let's move on to the next one. And this is the one that's, I would say there's the joint filing and then there's the good faith marriage. These are probably the most common ones that I see. Now, the battery or cruelty, it still has to be entered in good faith. The standards applicable, like VAWA, any credible evidence. It may be sought by the non-citizen spouse or the child, and the beneficiary was not at fault. Usually you're going to show this with a really good affidavit or statement, maybe a psychological report, and if there's any police records or anything else or letters from friends and family that can validate and verify the story, those are usually the things that we would go for on this type of case. There's a lot of misconceptions. People think that they need to stay in an abusive relationship to get their green card, but that's not the case. That's the reason why they have waivers for this. So if anybody this resonates with them, just definitely keep that in mind, because you don't even have to have the divorce decree to be able to file this. You just have to be able to show that establish this relationship, the factors that it was entered in good faith as much as proof as possible, and that they're establishing proof of the battery or cruelty. So let's move to the next slide, which is the hardship waiver. So this would be if for some reason you don't meet the qualifications of the joint or the battery cruelty or the good faith, this one does not require proof of the marriage was in good faith, but you have to show the extreme hardship that result if you were to be removed. This would very likely be with health, country conditions, things along those lines. Honestly, I don't think I've done one like this for an I-751. Usually, if anybody meets the qualifications, it's usually the good faith marriage and extreme cruelty. But this does exist. I think this is a bit harder to establish, but it is there. I think this can be mostly used for like country conditions changes, and for whatever reason you can't show the good faith marriage. So let's move on. So those are the waivers, and those are things to know. Now, what happens if the petitioner, the U.S. citizen, is not filing the joint is not possible because of the death of the original petitioner? That the death of the spouse excuses the joint filing and no separate waiver is required. They must comply with the other requirements showing the validity of the marriage timely filing. So you would file it very similar to a joint filing with the death certificate. So let's move on to now proof of timing. USCIS may not deny a petition solely because the spouses are separated or initiated divorce. Generally, what happens if we have a good faith marriage filing and they're not divorced yet is we'll file the I-751 timely, and then we'll ask for a request for evidence so that we can submit the divorce decree. So that's a very common situation, especially during COVID. It was taking a little bit longer to be able to get ready for, for lots of different things to get the divorce process. And now I think courts have caught up a lot easier, but it depends on where you're located. So if you were in the process of getting divorced, then you would want to file the I-751, but know that they'll give you a request for evidence, and then you're going to have to show it. The other thing that is another point a lot of people don't realize, and it can get complicated, is that you can amend your I-751. So, like, let's say you filed an let's say you filed an I-751 while you were still together, but then somewhere while that was processing, you start getting separated or in the process of divorce. So what you'd want to do is update the I-751 with the situation. The reason why is because you want to make sure that the I-751 is approved under the right basis. Because if it gets approved while you're not together and you're in the process of a divorce, but you filed under joint filing, then that's going to give you problems later on when you apply for naturalization, because they're going to be able to see when the divorce was filed, and they're going to be able to fit it all together with the timeline. So let's move on to the next slide. So the foreign national bears the burden of establishing good faith marriage. That's a lot of times they're looking to bank account, pay bills, children, things like that. But you can really you can overcome a lot of those things with an affidavit and therapy proof or letters from friends and family. There's lots of ways to establish proof. You don't have to have the traditional things. You just have to work a little bit harder and be a little bit more creative. So let's move on to the next slide, which, so what if the I-751 gets denied? Well, and let me go back for 1 second to make sure that I said this. When you file the I-751, you will get a receipt, and the receipt will come to you maybe in a couple of weeks, and that'll extend your green card for quite a long time. So that extension can be used, like I think I briefly mentioned, it can be used to get a stamp in your passport if necessary. It can be used for employment purposes, and it also can be used driver's license and all of that. Now, the good thing about getting that receipt when you do get it is it'll be good for 24 months. That means that you're after the card, it's still good for another 24 months. And you can use that to verify you're still in status and you still have a green card pending, or conditional green card. So if your I-751 is denied, what happens? Well, we need to look at the denial and see what happened. They might deny it because they think the marriage was fraudulent or judicially annulled. It also could be that they didn't attend the interview, or they filed or didn't file the joint petition within the time frame and didn't ask for an extension, or if they think there's false information. But really, it's best to read the denial and see what the situation is. Sometimes it's because the individual didn't amend, or USCIS didn't notice the amendment for moving from a joint filing to a waiver case. And so therefore, they didn't have it on file at the time. Now, so always read the denial and see, is it something that can be overcome? I've filed multiple I-751s for people. I mean, not like a ton of them, but generally they'll maybe get one denied because it was based off good faith and then they later got divorced. So it's really important to read it and see what can be overcome. So once you do that, then the one thing also that could happen is that you could be sent to immigration court. They're really a low priority for people if you don't file a new I-751 before you go to immigration court, if you get sent to court. So let's say you get denied and you could appeal it, but or file another one, if you file another one, then you would be able to prevent yourself being sent to immigration court if it's before the notice to appear is submitted with the court. But really what could happen is that if you did get sent to court, the judge can only review what was previously reviewed by USCIS. So let's say you filed a good faith marriage, and then you filed a joint filing, and it gets denied because you're not married at the time they adjudicate it. Well, you really need to just file an I-751 based off good faith marriage, a waiver. So the judge won't be able to look at that because it was never reviewed. The waiver wasn't reviewed by USCIS. So the court will have to be postponed. And under the Doyle memo, they'll probably just terminate that in court because they don't want to monitor that while you're waiting a couple years for the USCIS to adjudicate it. So bottom line is, if the I-751 gets denied, it's not the end of the world. You just have to read it and see what makes sense. Do we need to file another I-751? Which is usually the answer. Or is there some other option? There's one other thing that's very specific to I-751s and conditional residency. A couple years ago, they came out with another memo that helped clarify something. Before, there was this misunderstanding between USCIS and court. And what was happening is if a person got denied an I-751 for some reason and then later married another U.S. citizen, USCIS wasn't adjudicating the green card for the second green situation. But then they came out with a memo, I think it might have been November 2020 maybe, and it basically said that regardless of whether the I-751, how it resolved, you could file a new petition and that wouldn't hold you back. So that was a problem a long time ago. And then when they clarified that, then it made it a lot easier. So some people were able to file again under that clarification so that they wouldn't have problems in the future. Okay, so who would have thought that this would be so complicated? Well, in reality, it's not that complicated. It is when there's like little nuances. So, we're glad next slide, but I think, it's good that if you're interested in this, that you know about all these things. And, that I-751, like we said, if it was denied, it could send you to immigration court. But, the judge cannot review the I-751 that has never been reviewed by the immigration court. So generally what someone comes to me and they've been denied I-751, we quickly look at the denial, we look at what was submitted, we see whether there merits filing again. We usually file it again before they potentially get sent to immigration court. And even if they did get sent to court, we could probably terminate case while we're waiting for the I-751 to be adjudicated by USCIS. So moving on to the next slide, I think we've covered a lot of territory. The I-751 can be a little complicated, but the gist of it, I think the big takeaways would be look at your card, see when the expiration date is, and if you're filing joint, just make sure you file within the 90 days before it expires and have a ton of proof of the relationship that stems from when it got approved to the time that you file it. And then if it's based off any of the waivers, you're going to need a good statement that explains what happened and have as much proof as you can to establish that. And you're not held back by filing it within the 90 days beforehand. But if anything, this is usually when you're filing for a waiver. It's a very emotional time. So I would just at least suggest a consultation at a minimum to make sure that you understand all of these little nuances so that you don't have any issues. I-751 waivers, the processing time is quite long. I think by giving you a 24-month extension, they are giving themselves a chance to take a while. So, just do keep that in mind. And other than that, the good thing is there's options. There's options if you're not married. There's options if you file it late. There's options if the I-751 gets denied. So there's options. And if you need to amend it midway, there's options. So you don't have to lose that filing fee you already submitted. So, okay, I think that's that in the nutshell, Daya. How can they stay in touch, and what are we talking about next?
Yeah, of course. So if you guys want to stay in touch with us, go ahead and follow us on all of our social media. We're on Facebook, Twitter, Instagram. We have a LinkedIn and a TikTok. We also have a newsletter that goes out bi-weekly. That information can be found on our website, or we also have the QR code here. If you guys are enjoying these webinars and the information Attorney Powers is providing for y'all, go ahead and join us next week for our next webinar. It's going to be what is the E2 visa? But thank you all so much for joining us today, and we hope to see y'all next week.